in fact formulated in Jamaica. The records show that for those who wish to look. And of course, in a colonial context, the colonial office played its part, the framework for it played its part. But for those who care to look on the history of constitution making in Jamaica, they will see the move towards self-government and how we got to where we got to with the Jamaica Constitution Order in Council, 1962. So that is the first goal that we are seeking to achieve. It is not only symbolic, but it is substantive. And the second broad goal is to have a Jamaican head of state reflective of our Jamaican identity and our Jamaican nationality, and who will represent the nation at large, as opposed to a head of government who comes to office on a partisan ticket. But such is the nature of democracy. So there are provisions dealing with the establishment of the office of president, appointment to the office, and matters related to it. There is an innovation in the Constitution in that regard, because for the first time it will make a provision for the joint sitting of the two houses of Parliament. Currently, that is done by convention on the state opening of Parliament or when we have visiting head of government or head of state. But the matters relating to the office of president will require the Parliament, its two houses, coming together to deal with those matters, an innovation. We also have the Electoral Commission of Jamaica been entrenched in the Constitution. That was a goal that was set for a long time. And in fact, the Interim Act was made interim in name and nature until the steps to incorporate that commission could be taken. And so we are pursuing very important goals that have been set for the nation for a long time. And we will have to decide how far we go in light of this issue of the final court that is of concern to the opposition. I expressed to one of the members that which final court for Jamaica is an important matter. And although we are at this stage with the bill, that matter is not closed because there are time gaps. And certainly we do not move straight to a referendum. We already know that where we are in the life of this Parliament, we cannot complete all of the stages for the bill. The farthest we can go with cooperation is to have the bill passed by the Parliament and the referendum take place in the next Parliament. But that again is also dependent on the life of the Parliament, since we do not have a fixed Parliament, but just an outer date for it. And that outer date for this Parliament is September 15, 2025, and the outer date for the holding of elections is December 15, because the Constitution says that unless sooner dissolved, the Parliament would dissolve automatically on the 5th anniversary after its first sitting after general elections. And it first sat on September 15, 2020, after the 2020 September 3 general elections. So we know, having regard to Section 49, that we cannot achieve everything. I believe that the goals to abolish the monarchy are goals that would be pursued by another administration, a PNP administration. And I believe that we really have to consider what we are going to do with this work. We had the benefit of international observers last week who look at constitutional reform globally and comparatively. And they said many things which struck me, but among them is that in the Commonwealth Caribbean and in Africa and other parts of the world, a lot of constitutional reform process takes place, but very little constitutional reform, because so much time is spent talking about it, resolving issues, and not enough is done to move the process forward. So here we are. I would like to get a sense of where we will go. I know that those of us who are members of the House will become occupied with elections sooner than later, and even members of the Senate will be assisting their parties with the work. So this is the context in which we are at this stage. Nothing will go to the people if the Parliament cannot agree on these goals. I have spoken about my optimism, and some laugh at me. You know, when I was preparing for this meeting, I was looking back on the history, and I see that we have been stuck in a cycle. When the PNP leads, the JLP doesn't follow. When the JLP leads, there are issues. So though we had the passing of the charter when both sides came together, and that is a good example. And I know that out of that experience, there are some who say that the People's National Party should not cooperate with a Jamaica Labour Party unless and until the issue of the final court is agreed. But I would say that which final court is not a matter of a PNP court or a JLP court. It's a matter of the People's Court. And what progress we made to achieve the goals of independence should be viewed as a national goal. But I can't speak for the sentiments of the parties generally. I have been assigned a task, and I believe that the goals we are pursuing are goals that are in the best interest of Jamaica going forward. So those are my opening remarks. Depending on the signals, we will look at the schedule of meetings to review the bill. I have already consulted the diary for available dates. In keeping with the standing orders, it is the bill itself that will come under review, not a general discussion about constitutional reform, because that will have to take place at some point. But in order to make progress on the work, and in keeping with the standing orders, the focus will be on review of the bill. We will make a determination as to how we deal with invitations to members of the public for their feedback on the bill and other administrative arrangements. All right, so these are my opening remarks. Leader of the Opposition, I will invite you, if you wish, to say something.
Thank you very much. Thank you, Madam Chairperson, and I again wish you all the best for 2025.
Thank you.
Before this Joint Select Committee gets into the full business of today's initial meeting, please allow me to make a brief clarifying statement on behalf of the opposition so that both sides and the public are clear on where we are. The opposition has acceded to the request of the government to be a part of this Joint Select Committee of Parliament to deliberate on this bill, which seeks, among other things, to have Jamaica move to become a republic within the Commonwealth, and indeed we are now meeting for the first time. The aim for Jamaica to abandon the British monarchy has long been the settled public position of the People's National Party. Indeed, for several national elections, it has been a prominent feature of the party's campaign manifestos. From as far back as the 1970s, it was the subject of consideration by a committee established under the Michael Manley-led administration then. And 30 years ago, in 1995, in the report of the David Corr chaired Joint Select Committee on Constitutional and Electoral Reform, there was full and firm acceptance by Parliament of a recommendation that the matter of Jamaica becoming a republic should be pursued in earnest. Neither party has ever veered from that well-documented position throughout the years. And I reaffirm today that the opposition wants Jamaica to become a republic, delinking from the British monarchy, and more. I also say to this committee and to the nation that as far as I am concerned, the rights, interests, benefits, and privileges of the people of Jamaica are paramount in this matter, over and above everything else in the remit of the opposition and of myself as its leader. And it is with that in the forefront of my mind that I make this preliminary statement here. Madam Chair, during this 21st century, the Jamaica Labour Party, in or out of government, has never given to the public an indication of its support for Jamaica to withdraw from the British monarch's court, not even as an interim measure. Furthermore, by the tabling of this bill, the government has cemented its intention for the Jamaica to move away from the British monarchy while still remaining tied to the British monarch's court. The opposition that I lead, on the other hand, far from seeking to block either initiative, seeks the pursuit and success of both initiatives, two instead of one. We say time come for full decolonization. Our position rests on the foundational principle to which all political parties in democracies must abide. It remains the sacred duty of the People's National Party. That principle asks the abiding question: how can the vast majority of the Jamaican people be left behind, particularly in a process of decolonization? Is it not they who colonization had made less fortunate? Why should they continue to remain deprived of the fundamental right of access to justice at the highest level? On behalf of the Jamaican people, therefore, the opposition is forced, dutifully, to pose certain questions to the government, and which we are concerned should, at this historic juncture, be recorded by Hansard. Hence, we agreed to be a part of this committee from the outset. These are our questions for the government. 1. The bills to move to the Caribbean Court of Justice, the CCJ, as Jamaica's final court of appeal, were tabled in this Parliament for the second time 10 years ago. Are the people of Jamaica not entitled to be told why the government has not tabled the CCJ bills again, thereby signaling that both sides, government and opposition, will work together to accomplish the twin objectives of transitioning both from the British monarchy and from the British monarch's court? 2. Bearing in mind that the history of the constitutional reform process over the last 30 years has, undeniably, birthed a certain distrust factor, would the government not, like the opposition, wish for that to be put behind us before embarking on this leg of the historic legislative process and referendum for Jamaica to become a republic? 3. Is the government not under a fundamental duty to explain in clear and unambiguous terms why it is determined to proceed in this piecemeal fashion, instead of using the historic opportunity of this constitutional reform process to ensure that the majority of the Jamaican people enjoy the benefit of access to justice to their highest court? After all, the CCJ, as a globally respected regional institution, has long been provided to serve this purpose and is doing so with excellence that is internationally acclaimed. 4. Would the people and we ourselves not regard it as a welcome sign of maturity and wisdom to witness an agreement between the parties on the settled way forward for success on these new constitutional arrangements, regardless of which party wins the upcoming national elections? And is this not a most appropriate juncture for that consensus to be accomplished? Madam Chair, in considering those 4 questions, we should remind ourselves that the former Prime Minister, Bruce Golding, when he opened the Charter of Rights debate in the House of Representatives in 2011, made it clear to his colleagues that for success in these initiatives, consensus is essential. That is as true now as it was then, because that is what constitutional reform requires. The 4 questions I've posed, Madam Chair, are not posed for you to answer. These are matters relating to consensus in the reform of our Constitution and require answers to be provided by the head of government himself. Those answers are long overdue. Madam Chair, the answers that are forthcoming will determine the character of the opposition's cooperation in this exercise. The opposition is pushing for both sides to work together on both initiatives. We, as the opposition, need to be convinced that there is any better way forward than that. Let me repeat and stress. We need answers to these questions because the way in which the process is moving will condemn the majority of our citizens to remaining way out of sight back there without their fundamental right of access to justice being assured, and with no guarantee of their interests ever reaching the front page. The current approach leaves the people's interests behind. It is our sacred duty to bring them forward. Madam Chair, in the name of all that is good, all that is caring, considerate, and true, this situation must, in all conscience, be remedied before there can be opposition support. The opposition has sought the answers to these questions before, and now we seek them again of the government at this game-changing juncture in the country's history. As it stands, the government is leading Jamaica into a situation in which the British monarchy would have been ditched, the head of state would no longer be in Buckingham Palace, but Jamaicans would have to obtain a visa and would have to pay many, many millions of dollars to enjoy the privilege of gaining entry into their highest court, the court of the very same abandoned British monarch. What justification can there be for preserving such a backward, self-doubting, and undesirable state of affairs? The government must answer this question and explain its insistence on a piecemeal approach, which could only be premised on a lack of self-respect and shamelessness as a people. This opposition must reject that approach. We could not support or facilitate such a proposal, and certainly not under the roof of George William Gordon House. So, Madam Chair, I wish to make it pellucidly clear that we also have some other serious concerns in relation to some of the contents of this bill, which we would wish to tackle in the deliberations of this Joint Select Committee. However, the fundamental question of access to justice in the interests of the Jamaican people must be addressed first. As such, as from the adjournment of this morning's meeting, we may ask to be excused from further participation in this committee, pending the answers to these questions being given to the public by the Prime Minister. Thank you, Madam Chair, for allowing me to say those words, and I look forward to the rest of the procedural issues being addressed.
Thank you, Mr. Golden. Thank you for your questions. You have made it clear that you are seeking the answers from the head of government. I will make a few comments, but I see Senator Golding's mic is on.
Thank you, Madam Chair, and good morning to my colleagues. This is indeed a historic occasion, and as it is a historic occasion, Madam, notwithstanding the historic nature of it, we are still in a joint select committee that has a particular mandate based on how it was constituted and the motion approved in the House and the Senate. I'm a little concerned because I didn't understand that a statement was going to be read by the opposition leader this morning. And unfortunately, as has been raised many times by my colleagues, particularly my opposition colleagues, when we do that, the convention is that a copy of that statement is delivered to the members for them to follow. So I would just ask if copies are available for us.
Copies, you can have that one to begin with, and I will make...
Well, I wouldn't wish to deprive you of your personal copy, opposition leader.
That's fine, my dear. I'm happy to...
So can the Parliament please see that copies are made? Thank you. It's just my concern, Madam Chair, that as we embark on this committee, that we observe the scope of the work that we must do and the procedures that we are to engage. So that my understanding of this meeting was that you were going to set the procedural parameters for the work to be done, and the matters of substance raised would be dealt with at our next meeting. I may be wrong, and I'm guided if I am so wrong.
Thank you, Madam Chair. Madam Chair.
Hold a minute. Thank you for your comments, Member Shireen Golden. You have the floor, Member Hilton.
Thank you, Madam Chair. Madam Chair, having listened to the proceedings this morning, including your very extensive contextual statement, again, for which we were not privy to a copy, but we followed intently, and we understand the substance and the intendment of your statement. I would say that I think the Leader of Opposition was obliged, having listened to the contextual, very rich contextual statement, was obliged to respond in kind, to set the context, the tone, and indeed the framework in which the opposition will continue. So I found it appropriate. I think it is well within the member's right to ask for a copy of the statement, and the Leader of Opposition has dutifully obliged. But I believe that the contextual statement for a historic occasion like this is important, and I believe that this will enrich the proceedings and clarify for those listening what are the critical issues involved, and indeed we look forward to a discussion on the procedural aspects of today's meeting. Thank you, Madam Chair.
I think a Member Shireen Golding was just speaking to the prepared text, if I'm not mistaken, but I do agree with you. I anticipated a response. Context matter. We can't wish away the context. And I came into this meeting being fully aware of the matters articulated by the opposition leader. I think they're not new. They're not new. And Is there any other member who wishes to add something?
Sure. Let me just say, because you saw my face a little earlier, I'm a little annoyed. And I'm annoyed because I'm sitting here and all that is before the members, and I've looked at everybody else's thing, is a copy of the agenda. The Parliament has a duty to provide us with the motion that has been approved, a copy of the agenda, and I know we got bills from you, copies of bills from you before. So, procedure matters. The things that we are to be given to do the work of the committee matter. So not only do I not have those things, I also didn't have a copy of the opposition leader's statement. I like to be apprised of the documents that are to be before the committee. So I just registering that, and I'm sorry I have to say it, but I have registered it, and to date I have not received it.
Madam Chair.
Yes,
Madam
Member
Chair,
Hilton.
my own observation is it's unfortunate. I believe had the member been here from the beginning, she would have had a proper sense of the context of the meeting. Well, I did not see you take a chair. I did not see you take the chair. So I agree. I was going on to say that I understand the substance of what the members asked for, but I think for a full understanding, I don't know if your statements were prepared. They seem very off the cuff, but you may want to have them issued to the member, a copy of that issued to the member as well. But I agree that the documents should be properly prepared and presented.
I don't know why the line of a song is coming to me, how we open up the quarrels between the present and the past. But Member Shireen Golden, I had asked the clerk about the file that is normally prepared for each member of the House. So I understand your concern. The file I have has in it the memorandum to members of the House with the usual indication of attendance at the date. It also has a reminder that was sent out to members, and it does have extract from the minutes of the Honorable House of Representatives held on December 10, public business, where it was resolved that the House appoint a select committee comprising of myself as chair, Ms. Tamika Davis, Ms. Carencia Morrison, Mr. Dwayne Smith, Mr. Mark Golden, and Mr. George Anthony Hilton, to sit jointly with a similar committee to be appointed by the Honorable Senate to consider and report on the bill shortly entitled the Constitution Amendment Republic Act 2024. It is a certified extract from the minutes of the House, and we also have an extract from the minutes of the Honorable Senate held on December 13, 2024, where Senator the Honorable Aubin Hill, the Minister of Industry, Investment and Commerce and acting leader of government business, having obtained suspension of the standing orders, moved the motion that the Honorable Senate appoint a select committee comprising the following members: Senator Charles Sinclair, Senator Ransford Braham, Senator Shireen Golding Campbell, Senator Peter Bunting, and Senator Donna Scott Motley, to sit jointly with a similar committee appointed by the Honorable House of Representatives to consider and report on the bill shortly entitled the Constitution Amendment Republic Act 2022. The motion was seconded by Senator Cavan Gale, and the extract is certified. All members have been provided with a copy of the bill. and a copy of the Constitution, what I call the IRI copy of the Constitution. The other documents will come. Madam Clerk, please ensure that the bundles are constituted. Now, just to say, Member Marco Golden, Leader of the Opposition, your ask about the position of the government, essentially, is not an unreasonable ask to my mind. In your questions, however, are clues of important differences in the approach that People's National Party takes from a Jamaica Labour Party. I don't think that it's unique that competing political parties have different perspectives. So while I am not seeking to answer your questions, but I will do my best to ensure that answers are provided to you, I just want to say that this is not a piecemeal approach to the reform of the Constitution, not at all. The terms of reference which informed the work of the Advisory Constitutional Reform Committee sets out clearly the overarching goal of a Labour Party administration in relation to constitutional reform. The research shows that attempts to do everything at once have failed miserably across the globe and in the Commonwealth Caribbean. And it would be most unwise of us if we do not heed lessons that stare us in the face. We have not had a referendum in independent Jamaica. And I think that more than a Jamaica Labour Party administration, People's National Party administrations have spoken passionately about constitutional reform, passionately about reforms that would engage the deeply entrenched alteration mechanism. And anecdotes are widespread about why the work did not go forward because of this fear of holding a referendum. There is no, within the political culture, anecdotes that referenda are really not on the subject matter that goes to the electorate, but on the performance of government. Prime Minister Holness has decided that he would take the political risk to move Jamaica forward and to move on. But like all risks, they have to be managed. And we have seen how, even with smaller changes, systems have gone into chaos. So we do not share the view that this is a piecemeal approach at all. We are saying that we are implementing the reform goals in phases, because if we bite off more than we can chew, we may choke. And we certainly do not want to throw our system into chaos and risk instability in the democracy. So we part company on that perspective. We also part company on the perspective that not dealing with the court at this time is leaving the majority of Jamaicans behind and disregarding their rights. The data shows that appeals to the final court are the smallest number of appeals, smallest number, not just in Jamaica, but generally, even in jurisdictions where their final courts are resident within their borders. The data shows that. The data shows that culture will determine the extent to which matters are appealed. So we have to be very careful that we do not make broad sweeping statements that are not verifiable and not supported by the data. So we totally part company with you on those statements. Like I said in my opening remarks, you do not get to appeal without trial, and in Jamaica's case, without a first appeal. Even though constitutionally, some matters can go by way of case stated to the Privy Council. Even in those cases, they still ask that an opinion be provided by the local appellate court. So we really part company, even as I agree that Jamaicans are going to be left behind if we do not deal with the issue of the final court at this time. Part company on that at all. Yes, you see, if I agree with you, then we'd both be wrong, and I don't want us to both be wrong on the matter. Right. So, again, you said that these goals would be pursued by both sides, regardless, notwithstanding whatever comments you may have on the bill itself. That is why we are reviewing it. I'm wondering, though, whether, given the constitutional provision at 49, right, I need your undivided attention. Don't let Senator Shireen Golden distract you because you have the same Golden name. Don't let Member Tamika Davis distract you. Right. I'm saying that the founders of the Constitution, in their wisdom, have built in delayed period. And I asked Dr. Barnett at our last meeting what was his view on what these periods should be used for. And he said, in addition to what we know, it really allows for reflection, serious deliberation. So we have this 3-month period. One has passed already. And then we have another 3-month period after the conclusion of the debate and the taking of the votes. The matter has to go to the Senate, and then we have at least 2 months and no more than 6 months. So there is time before you make your final decision on how we go forward to still proceed with the business of reviewing the bill. There is time. I can't force anything. I'm merely asking. So I am asking from the perspective of the shared commitment to achieving the goals being pursued. Right? So the real difference between the People's National Party and the Jamaica Labour Party at this time, as I understand it, and I stand corrected, is that the People's National Party opposition wants it all at once, and there is no room for discussing which court is in the best interest. Leader of the opposition, I'm going to help you protect yourself, you see, because when you made some statements the last time, people went away interpreting them in all kinds of ways. So the issue of full decolonization is not going to take place simply by removal of the court, because what troubles Jamaica more than anything else are some deep cultural issues. And I think that Bob Marley expresses it well in one of his songs about emancipating the mind. So there's a lot of work before us. There's a lot of work before us. And the only way we're going to make progress is to take it step by step. Now, I understand the distrust. I understand. Make no mistake, the distrust is not on one side. But we will have to work to regain the trust. The trust is not only broken in the parliament, it is deeply broken in the society. and not only over political matters. So make no mistake, our work is cut out for us. Why not now? We can't do it all at once. Let us put in a program that can reveal a commitment to dealing with the matter. Now, I say that there are stages. Bear in mind that we are going to be fully in campaign season not too long from now, and that may take up a lot of our attention and time. But I will report to the head of government on the questions. I will ask the government side to meet, and we will exchange some perspectives, because as you know, heads of government and heads of parties are also briefed and they take advice. Nobody comes as a single entity. You have a whole constituent behind you. And the truth is that there are different views on the matter. And it is not for want. Prime Minister Holness did make an effort to get his team together. In fact, I ran one of the polls, and the poll results came back with divided views. And people feel very strongly. They feel very strongly. And I don't think it is wise to just dismiss the view. What we have not had yet is a process where we hear the views, we assess the merits of the views, because a decision will have to be made. But the thing about the judicial branch that it teaches you is the importance of due process. We don't get to outcome without process, because we will need ownership of the institution that emerges.
Thank you, Chair. May I commence by wishing you a very happy and successful New Year, and offer my own commendations on the historic role that you personally have played in taking us to this point where we are truly on the road to republic. I have listened very keenly to what you have said. Most of it I've heard before. But since you're asking the question, and you have posed it in the way of really an observation that we can't do everything, I just want to remind you that we are not asking for everything, that we understand that the process of constitutional reform is a highly complex one, and that even when there is agreement amongst some of the players, the public might not share the views of the parliamentary personalities. I believe that asking for the discourse about the CCJ is a small point in terms of time and in terms of process. But it is of significance nationally. People should at least understand why the government has so many reservations about the CCJ, and why it is that the government seems to be wedded to the Privy Council as the final court of appeal, because wedded it is. And it seems like an incomplete divorce, a decree nisi, which will never become absolute, to persons who are concerned about the final court. And I say this because, Madam Chair, the wavering on the part of the government is concerning. I have personally expressed to you that there is no trust in this matter, because all the assurances which we have received about the government demonstrating and coming to the people and saying why it is that they want to remain with the Privy Council, or they want to have a local final court of appeal, they have not been articulated in a manner which even the opposition could appreciate, deliberate on, dissect. And I'm saying the government does not only have a responsibility, it has a duty to come at this stage and not some future stage when a bill is passed and we're waiting on a referendum to be announced, to explain to the people why it is that the Privy Council is to remain our final court even as we leave the monarchy. That is an anachronism which a number of persons, Jamaica Labour Party and PNP persons, members of the judiciary, cannot understand. We have had overwhelming support for leaving the Privy Council and ascending to the CCJ. The Jamaica Bar Association made presentations to us. We had meetings with the press where members of the press could not appreciate the reasons for wanting to remain with the Privy Council. Almost in every fora, we have had those expressions, and it is only on the part of the government that it appears that there is resistance. You yourself have said, Minister, that there are many people in the Jamaica Labour Party who feel that we should take that step. There have been constitutional amendments which have been passed in this House, tabled and taken on the same day. I do not imagine, Minister, that over on the government side, everybody would have supported that. I believe there would have been some dissent, because there are people who appreciate how the process of constitutional amendments must take place. But the government nonetheless proceeded. So I do not accept your view, Madam Chair, that this is a matter on which there are differing views. There are always differing views. Even at the level of the Privy Council, your final court of appeal, there are dissenting.
No, the Privy Council is Jamaica's final court.
I withdraw that remark unreservedly.
Don't be cheeky with me.
I was just thinking, I think that it was triggered by your comment that there are people who think of the Privy Council as a JLP final court and the CCJ as a PNP final court, a matter which
But I'm sure you would have heard the views.
I totally abhor.
You've heard the views. People have said that. No, in the context.
No, I didn't hear it before you until you said it, Madam Chair, to be fair. But I think that I made my point. I do not want to delay the Joint Select Committee any further.
Well, just to say that I don't believe it's accurate that it's only on the part of the government that there is resistance. I don't believe that is true at all. And I don't know that I would call it resistance. I think it is a matter of managing the political risks in making the changes all at once. Senator Scott Motley, the level of concern that has risen in inquiries about how justice is administered in Jamaica, let me tell you, it is of serious implication and it is of serious concern to me. So that I don't want there to be any misunderstanding about where the difference is. I do agree with you that as we move to make this change, we should indicate where we are. But what I find unsettling is that there is an outright rejection of a view of someone who says, I am not yet entirely sold on the CCJ for reason, or I am comfortable with retention of the Privy Council. You know, the International IDEA team, the International IDEA Institute for Democracy and Electoral Assistance, shared some important insights with us last week. I forget the specific point I'm about to make, but Member Kerencia Morrison, I see your mic is on. We're still on item number 4 before we get to 5, which is the other major item. But I did anticipate 4 to be a major item, and that is where we are on the agenda.
Thank you, Madam Chair. I just want to ask 2 questions. First, I thought that this would have been the meeting to discuss procedural matters,
but I've listened to very interesting arguments from both sides. And as I sat here, there are questions here that I would like to raise. One, does Jamaica becoming a republic rely on either the CCJ or the Privy Council being our final appellate? Is that a necessary part, right, of receiving that status? Also, do we have jurisdiction that you'd say they're a republic, they have enjoyed that status where the Privy Council is the final appellate? And for such jurisdiction, I think Trinidad is one. Could we, and I'm going to piggyback on the words of the leader of the opposition, backward, self-doubting, and their state of affairs undesirable. Also, Chair, I'm of the view that the right to choose is one that is sacred, and this right can include a process. Are we limited to the CCJ or the Privy Council as our final appellate? I'm asking this on behalf of many Jamaicans who may have this concern. Isn't it at all possible that Jamaica could have in its own constitution, maybe it will take an amendment, its final appellate, where we have legal luminaries, law lords, maybe from all over the world, I don't know. But is that within the bandwidth of possibilities? Thank you, Chair.
Senator Braham? I'm coming back to you. Yes, I'll come to you. Thank you. I'm so sorry. Thank you for the questions, Senator Morrison. I think Senator Braham may assist in an intervention. I'm going to, yes. Go ahead.
So, member, in light of that, the fact that we may have a range of choice in this argument, I would think it strengthens the point about this being a process, one that will take some time, and one where we may even say that it should not prevent our having that status, Jamaica becoming a republic, right? It's a part of a broader process. Thank you.
Now I recall the point that stuck with me when the delegation from IDEA International shared their observations from their comparative research around the globe. They said that when participants come to the process, being stuck in their mind with what they want from the process, leaving no room for revisiting their preconceived positions, it makes the process extremely difficult. And so, if we are going to benefit from the wisdom of others, it's going to be important that even when we come with predetermined outcomes, that we can listen, and listen with a view to being persuaded of a better position. Listen in principle. So, the thing about a principle, is that it applies across the board. It's not being put for application to one side without another side. The research shows that when participants come to the table with predetermined outcomes, it becomes very difficult if there isn't broad agreement on those predetermined outcomes. Right, and it is because of that the Holness Administration decided to proceed with the ones on which there is agreement, while you work out the others where people have different views. Yes, Senator Braham.
Chairman, I will not indicate at this time what my position on the CCJ Caribbean Court debate. I suspect there will be an opportunity to do so, and I will take that opportunity when it is given. I don't think this is an appropriate time to do so, but in any event, I am of the view that the transition from the British monarch as our head of state is of sufficient social and psychological importance that we should proceed with alacrity, and that the two are not necessarily tied. And indeed, if there is consensus on that matter, we should deal with that. And it would be a shame if we do not deal with it and another 30 years pass and we still have the monarch, which I have been developing that sense of foreboding, that 30 years from now, His Majesty King George would be still our head of state. And that idea is distinctly frightening to me, but apparently not to others.
I think the remarks of Senator Braham may shed some light on the questions you have asked. And you did answer one, that within the Commonwealth Caribbean, we do have Trinidad and Tobago as a current example of a republic that has retained the Judicial Committee of the Privy Council as its final court. Just in answer to that. The questions cannot all be answered at this time. I would like to move to the next agenda item, and that is procedural matters. And I do so bearing in mind the caveat from the opposition leader in respect of members of the opposition on this team. Here is where my headspace is. With the deep appreciation for the constitutional alteration framework, I do believe that the matter of the final court is a matter that we will have to make some serious progress on before we get to the putting this bill to a referendum. I do believe that. I hear among the many asks is really a desire to know the government's position. And this is not new, because the only way you can respond to the arguments is if they are clearly articulated. So I take no issue with that ask. We have to keep an open mind. All of us have to keep an open mind. Which final court is best for Jamaica is not which final court is best for the PNP or which final court is best for the JLP. We are given the privilege as representatives of our political party to make decisions on behalf of the people in this representative democracy. So we need to understand that very clearly. When we come here, we are not here in a personal capacity. We're here in a representative capacity. And, you know, we have to respect the views of others. So those of us who have a little more knowledge will have to guide others. But we certainly cannot be dismissive of anyone's views, because the issue of justice goes deep. There was a time where everywhere across the island, once there is a problem, you'd see a placard, "We want justice." In my home, there was a tease. I would say to my husband, "Justice, they're asking for you." Right? But that is just how deep the issue of justice is. So make no mistake, it is not lost on me. My entire professional life has been interwoven on matters of with matters of justice. And I know I'm not unique in that regard. So, having said that, I would like to now move to look at the procedural matters for the running of the committee. This is not to be interpreted as dismissing anything. It's just an attempt to make progress on the work.
Madam Chair, I feel compelled to just make a point as you move into the procedural matters. In looking at my motion, the motion that was tabled, the motion approved in the House and in the Senate for the formation of this committee, I just want to make the point that I know that the matters that will come for discussion in this committee are matters that perhaps have already quite thoroughly been discussed in what was the Constitutional Reform Committee convened under your chairmanship, I believe, that produced a report. But I want to be very clear, and I want our country to understand very clearly that the Joint Select Committee of Parliament is not an extension of the Constitutional Reform Committee. And I, as a member of this committee, who did not serve on the Constitutional Reform Committee, expect to be able to undertake this work with an open mind, considering the provisions that have been put before us for discussion, getting the advice of those who come before this committee, and certainly rendering my views on behalf of the people of Jamaica in the context of what I learn and glean in this process. So while yourself and other members on this committee seem to be having a discussion about matters arising prior to the constitution of this committee, please understand that not all of us were in the room, and we would appreciate engaging the work of this committee in a way impartial to whatever it was that transpired in the room of the Constitutional Reform Committee. We are not the Constitutional Reform Committee. So I'm asking my colleagues just to bear that in mind. Yes, there are going to be some preconceived views and positions. I've already heard some stated here today. I would like those of us who have not had the benefit of this deep dive and discussion amongst each other to have the benefit of proceeding in this committee openly, transparently, and looking at all of the matters without having any preconceived notions as to where we're going to land. May it please you.
Thank you, Senator Golden. Now to the matters at hand. The report of the Constitutional Reform Committee was tabled as a ministry paper in the Parliament. We have since done a publication of it, and I believe there should be a copy for all members of this committee. For those of you who do not usually take documents from the Parliament, you may have missed the ministry paper. I'm encouraging you, especially the government members, to make sure you take up documents when they are put in the Parliament. Right, but you'll get this nice fancy copy. And for those of you who walked out and left your constitution, you can pay for a copy. And we will take the reimbursement at the Ministry of Legal and Constitutional Affairs because we had to pay for it. Fun and joke aside, you'll get your copy. All right. The establishment of this Joint Select Committee is an honoring of the commitment we made. I reference the report because not everything in the report made it to the bill. And we have revised an aspect of the recommendation around the Office of the President in respect of the appointment process. And that was a direct response to the feedback received from the Leader of the Opposition and from former Prime Ministers Pattison and Golden in a public forum, and generally from just listening to concerns raised. So I anticipate that we will be looking quite robustly at the mechanism that we have put in place. It is true that this is not intended to be a revisiting or a repeat of the Constitutional Reform Committee's process. It's not intended to be, and it cannot be, so that not all of the issues are going to be deliberated on at large. We really are going to be deliberating on the provisions of the bill, Most of it, I think, relate to the office of president, but I come with an open mind to hear. So we have to determine whether we invite members of the public to send their feedback to the committee on the bill, to invite submissions on the bill. And then we have to determine, depending on the number of submissions we receive, whether those persons who make submissions will be permitted to do a viva voce presentation, or we consider the submissions on paper. There are merits and downsides to both approach, but we won't know until the formal invitation is issued and we actually receive the feedback and the submissions. But my thought on the structure of the work of the committee is to spend the first few meetings actually looking at the provisions of the bill, clause by clause. Because the purpose of the Joint Select is to aid the House in committee stage to review a bill clause by clause. So even before we open up to the public, considering submissions from the public, that the committee itself would spend some time looking on the clauses of the bill. And that would take up the first few meetings. We can determine that not everything will require a deep dive. We don't have to go through the whole of the bill because many of the clauses relate to consequential amendments. So we can agree that those are necessary consequentially upon the other changes being made. And then we can focus on the clauses that would require review. So that is my proposal. We spend the first set of meetings looking on the major clauses of the bill as a committee while we await the receipt of submissions from the public. Does that, I'm sorry? You've been in committee. Does that proposal find broad favor with members? Yes?
Thank you. Just to clarify, what you are proposing is that apart from the consequential amendment provisions,
Right.
which are uncontroversial,
Right.
as long as they're correct.
Yes,
Yeah.
of course. We'll check for accuracy.
But
naturally.
the main substantive clauses in the bill, you're proposing that
As a committee, we
the
spend some
committee
time,
would go
first of
through
all.
that
Yes,
before hearing from the public.
yes.
I see. So
Yes.
the public will, of course, have comments on those very clauses, right? So you'd want to take those after
Yes,
we've
certainly among the committee members we would. It's important to get an understanding of what is, first of all, what is the legislative intent, whether the intent is reflected in the draft, and whether there is any other approach that could improve on what we're seeking to do. That really is. And where there may be matters, any further proposal for consideration on the framework, since we did vary from the recommendation in respect of the nomination and confirmation process for the office of president.
Yeah.
Right. So the bill has, I think, 32 clauses, if I am not mistaken, 36 clauses. And it has schedule, and the bulk of it, outside of the ECJ provision, the bulk of it relates to the Office of President and consequential amendment. So my proposal is that we would spend some time seeking to understand what it is that we're doing. And if there are proposals within the committee for any tweaking, or there is any thought which would not have been considered by the committee on any of the matter in the bill, then we can look at that. Because I think the public will need some time. We'd have to give at least 2 weeks for them to send in, even though I had put everyone on notice when the committee was established on December 10, and ask that those who intend to make presentations to start considering their presentations. All right? So I've looked at some dates that we were...
What is the public being asked to send their recommendations on?
The bill.
Yes, but you were saying that inside the committee we are going to look at it, determine if it needs tweaking.
No,
I'm not very clear
right.
on the
So the committee to even properly respond to proposals or submissions from the public, we need to have an understanding of the bill.
No, I understand
Right,
that.
that's
but
all I'm saying.
What I want.
So we would begin with the committee itself going through the major clauses.
Yeah, but if we are tweaking.
Then of course we would have to consider provisions,
Then,
submissions that come in at a
no,
different stage.
Just allow me,
Yes.
allow me, Chair. So we are inviting the public to make submissions. We are, I'm not sure how you're going to be communicating to them submissions on what. But you're sending them a bill, and you're asking them to send in their responses within a certain time. You say you have already put them on notice since December. That's what you just said. I'm repeating it. Right. So if the committee sits down and decides to tweak, it's not going to be the same, necessarily be the same bill, the same clauses, that, as the public would be invited to comment on. That's just where I have a little confusion.
Not what I'm saying at all. I think that the bill may require some explanation for those who have asked questions generally. So, for example, just by way of example, we had submissions to the committee from one of the civil society groups on the body to confirm. The process for the president is a nomination and a confirmation process. We have made some changes to the nomination stage based on the feedback and our tracking of it. I suspect that there may be other comments to come in respect of that. There have also been comments in respect of the confirmation phase. I think that it may be helpful to the committee to understand the rationale for the recommendations in terms of what made it to the bill around the appointment process, even before we consider the submissions from the public. That's the point I'm making.
I want to join with my colleague, Senator Shireen Golding Campbell. We cannot treat this joint select as though it's a continuation of the discussion in the CRC. And therefore, the public have to, while we are understanding what it is, the public must be clear as to what they are commenting on. And the public must be given an appropriate time in which to formulate their comments. This is, although you say it's 36 clauses, it is a complex piece of legislation. The introduction of the president, which is the republic, is not easy to understand and distill for precisely what you just said. The entire process, firstly of nomination, then get into a consensus. Then if you don't get consensus, what you do again, and then the final thing where it goes, and it's a simple majority. those are matters on which the public must be allowed an appropriate time to engage. The implication of the composition of the Senate being enlarged. And Madam Chair, I beseech you to allow the public sufficient time to be able to make appropriate submissions. I also want to suggest to you that we proceed in a way that we have done on other Joint Select Committees, and that we have a category of persons who we directly invite to make submissions to the Joint Select. I do not want us to go into make the error of confusing the fact that they made submissions to the Constitutional Reform Committee with feeling that we already have these submissions on record. This is a Joint Select Committee where it's very important that the public be given an opportunity to participate. And the one last point I want to make is a referendum requires that the people vote. And I want a yes vote. So if we're going to have a yes vote, we have to make sure they understand what they're going to vote for. Or otherwise, you know, the easiest thing to do, just vote no.
Having said that, do you have any recommendation of any special persons or body that the committee should invite to make a presentation on the bill?
Chair, I think that we have persons who made recommendations. I know the Jamaica Bar Association.
It may be helpful
we have a list.
If it is a view of the committee, which I believe it's a good approach, for us to, at this stage, decide on specific persons. It doesn't have to be an exhaustive list that we would want to hear from, then we can at least send specific invitation to those persons, in addition to the general notice that would go out. So let us look at special invitees. For submission.
Chair,
yes.
Just before you, even as you do that, I think the matter has been mooted in this discussion, but I want some clarity on exactly the scope of the responses that we're seeking. Is it confined just to the bill and the provision of the bill, so that matters, so if in fact there's a criticism and someone wants to urge another view, because this is part of the legislative process.
It must include omissions from the bill.
Right. Yes, amendments.
And
yes.
And omissions, it can address things that are not in the bill. It should be.
So that's my question is the scope. Is it amendment, omissions?
Impossible. That will never happen.
Member Hilton, I am trying that you get undivided attention, but your colleague's not working with me. Yes.
No. So when I ask the question, the scope of the responses, because if we are clear about that and we enunciate that, then who we invite as a special invitee as opposed to general thing will really address, to know what they address and what the subject, or we limit the subject of omission or amendments.
It may be helpful to just direct you to Standing Order 77-7, which is what really guides me. People relegate the standing orders without appreciating that they are regulations of the Constitution, you know. The deliberations of a select committee shall be confined to the matter referred to it by the House, and any extension, and in the case of a select committee on a bill, to the bill committed to it and relevant amendments. So that's it. That's it. Well, that's why we're having this committee, so that we can have the wisdom of the lawmakers, right? You're all lawyers, man, my goodness. to the bill, the subject matter of the bill. Subject matter, but let's see. Remember, we're embarking on a real historic move, right? Hopefully those who come behind us will find us faithful, and history will record us favorably. So let's go to the special invitees for sub. If you have any suggestion, I heard Sotevoshe, the Norman Manley Law School. I'd heard that, which is typical. The Jamaica Bar Association, those are two. May I ask, instead of speaking generally, let's speak specifically. So 3 come to mind: Cafe, Jambar, Law School. Consensus on those 3? JFJ, 4. Jump, 5. Do you think that perhaps each political party should make a presentation, your NEC and the what's the equivalent in our side? It escapes me now. Kerencia, standing Deputy Gensec. The standing committee? The central executive, yes. Yes.
Chairman, if you're going to invite, I would hope that we would not limit ourselves to the usual suspects. I mean, there are not other people in the country. Yeah, man, there must be other people. Maybe the Jamaica Agricultural Society, maybe the church, maybe the Society of Dancers or somebody. But they're the usual suspect, all the liar.
It's true. It's true. And in fact, it's a criticism, it's a comment that we have received within the committee, that it's the same set of people who are invited from time to time. And in fact, but the NEC and the central executive, you think that that's... I know, but if... They?
Perhaps we could give some consideration to the groups, I mean, rather than try to just, I take what Senator Graham has said very seriously, because at the end of the day, we need the widest understanding of what we have embarked upon. So if we can broaden, as he says, not just confine it to the usual suspects. I'm sure he didn't use that word advisedly. I will speak to him on the matter after. But I understand what he was saying, that as wide an organization, a grouping of organizations as possible. And I think if we always remind ourselves of the end goal, between us we can make some suggestions by, I don't know, according to if we have to make the suggestions here, Chair, or you could give us a deadline by which we could send in our recommendations.
I think we can start with those that come to mind now, so we can get the ball rolling, and then as others come to mind, we can add them. In addition to the specific invitees, there will be a general notice to persons. And just to say, as you mentioned, as much time as possible, the day the bill was tabled, it became available to the public, the very day. Well, you know, I
asked what I have shared. Yes, last night, I shared it with quite a few people, because there are people who didn't even know it was tabled. We have to be realistic.
That's a problem that we face, though. But I think that we have to help to hold people to account and to be responsible, because you can't complain legitimately that you don't have access when it's your own failure to access the bill that creates the problem. We mustn't make the problem any bigger. We really have to direct and guide our citizens. It took a lot. It took a lot to make the bill available on the day it was tabled, not only in the parliamentary space, but in other spaces. So, you know, when we find solutions to real problems, we have to respect those solutions. This is the digital age. And the good thing about it is that just about everyone has a smartphone and can pull up a document. So those who really know, who wish to find the bill, will find the bill. I kind of part company. I know we still have a digital divide and we may have to help, but we have done a whole lot to make the bill available, because bills are publicly promulgated and it was not just restricted to the online site of the Parliament. So we have the list of the Jambar, we have the Norman Manley Law School, we have the Cornwall Bar, huh? All right, the Bars Association and the subsidiaries, all right? I'm coming to you. And then we say Cafe, JFJ, and JAMP, the University of the West Indies, Department of Government, or whichever relevant part, the University of Technology. They have law faculties in particular. Huh? The UTech, NCU. But remember now, you know, as you have been pointing out, Senator Scott Motley, grassroots vote. It's not everybody who are in these institutions that go to vote. We hope that they will. All right, so it's not an exhaustive list, but in principle, the committee is agreeing to that invitations be sent to specified persons as well as a general invitation, and we will leave it open for other persons to be named specifically for which invitations to go out. All right, so that's one.
General invitation that goes out, when I've seen from other joint select, they are not done in a prominent way, and probably this one need to be given greater prominence.
All right, very well. And by that you mean like a center spread. We're going to put it up. We will put it up. We had spoken internally in the ministry of using some innovative ways. And I think we will have to engage the rest of government so we can run them. A lot of, like the tax office, for example, has a little portal while people are waiting. We can do the printed notice, put at other places where members of the public are. But remember now, you know, certainly committees that I have been involved in have never been short of getting submissions from people. All right, so that's the first thing, the specific and the general invitation, and they should be as prominently displayed as possible.
Can the Parliament indicate whether or not the bill is on the website for the Parliament? It is on the website for the Parliament?
The bill is also at the Road to Republic website, and it's at the Ministry of Legal and Constitutional website.
Okay. Can I just make a suggestion then that our communications manager in the Parliament, I had hoped she would have been at this meeting, because she's watching. Oh, great. Okay, because I know she will have a wealth of recommendations and initiatives that she could roll out in terms of getting the bill to the public and also getting the information as to what is happening in the meetings going on in a robust way. But if we could perhaps, Ms. Cohen, sort of directly engage with her so that she's engaging with the committee chair to ensure that she's matching up with what we're doing, so we do have the widest dissemination. I'm experiencing her doing that in another committee, and it's really quite effective.
So the next matter would be a schedule of meeting for the committee
No, I was just, before you close that, I'm mindful of the general and the specific and general, that in the notice that we include the fact that this is not just confined to Jamaicans at home, that the interest has been shown by the diaspora. I think they should indicate that they are welcome to submit.
By the way, as you spoke to that, you would have seen that we did something to try to honor successive administrations' commitment to have consideration given to the interest of Jamaican citizens living abroad on the matter. It's a contentious issue, but I think there is broad agreement because Jamaica's partnership is between government Jamaicans at home and Jamaicans abroad. And I think that's a general approach across administration. So we have tried, even in the face of controversy, to make an accommodation for that, because the research shows that successive administrations, Jamaica Labour Party and PNP administration, have made a commitment on that. Yes. So you would have seen that reflected in the clause dealing with the independent senators, not to have them, but that the interest of Jamaicans be a matter of consideration. I suspect that that matter is going to be, we're going to hear some interesting views on it, because I've seen a lot of reaction to it, and the views go in both directions. All right, so again, subject to the other matters that have been raised, I am thinking, if we're not overcome by other things, we could look at Wednesdays for this meeting. Leader of the opposition, I'm watching your body language, and right. We're going to end shortly, but I don't want you to leave before we end. But you have your members here. Wednesday the 22nd, we can just reserve those dates. The 29th of January, and perhaps Thursday the 30th if possible, depending on, we know what we're dealing with. Okay, we'll have to work it out. All right, and then for the February dates, I wouldn't go beyond February. Well, we can do Thursdays would be better for most people. 10 a.m. She will short out her schedule. It doesn't matter for her to manage, you don't have to tell me that. No, I'm saying everyone will sort out their schedules. One of the reasons for giving a global idea. That's fine. If they're...
Understand, when you say the 22nd, is it 10 or 2? It's always...
It's a pre-scheduled meeting, then it would be the afternoon.
So 2, okay.
Right.
So 29th is 2, the 22nd is 10.
All right, so we have Wednesday the 22nd, Thursday the 23rd. Wednesday the 29th, Thursday the 30th. Well, I'm just...
What you're suggesting, twice a week?
No. I'm putting out some days. And then for February, we have Wednesday the 5th. No, the 12th is the day between the prorogation of Parliament and the start of the new year, so I wouldn't put the 12th at all. Because we prorogue on the 11th, and then we have the state opening on the 13th, so that wouldn't be. And then we have the 19th and the 20th, 26th and the 27th. We can then decide from those dates. I'm not taking it into March, because I know budget debate is going to come and everybody else will have a set of things, and we have other matters. All right? So 22nd would be the next meeting, Wednesday the 22nd. Okay. And then we can look at 29th and 30th thereafter.
Okay.
All right?
We can decide after.
And then we can decide. If there is no other business to be raised, the quorum is as, the standing orders provide for that, you know. Quorum of the committee. Right. So generally the quorum is 3, but I find that is a little low for a matter like this. But I also know that the experience sometimes is that people go all over the place. Can we at least show the people, and I know the other matters that must be addressed, that this matter is of importance to us as a nation, and that the privilege that we now have in the seats that we now have, that it means something. All right, we can keep the quorum as is for now, and then if anything, we can come back to this matter in accordance with the standing orders, in accordance with. All right. Yes.
Is this committee also going to be meeting by virtually?
We will have to,
for persons?
when we get there.
Okay.
Not for the first few meetings.
Not for the
Yes.
first?
Not for the first few meetings.
Okay.
Yes, but of course, we will have to look at what is convenient. All right? So date and time of next meeting would be the 22nd, Wednesday the 22nd at 10 a.m. 22nd. Then let me thank you all. Let me thank you all for showing up in full. Let me thank you for your interventions. We have a lot to think about, and let us be really grateful for the privilege that we have at this time to be part of this important work in our nation.
A question really directed at our legislative council. If I'd just ask her to opine on it, and if not today, at the next meeting. Can you just indicate when a joint select committee meets, which of the standing orders of the houses is the controlling standing orders? Is it the House or the Senate, and does that depend on where the committee was constituted?
It's the House.
It's always a House?
Well, I did check that, and I know for this purpose it would be the House.
Yeah, can you just look at that and let me know what the rationale is? Thanks.
All right. Any other point to be raised by any other member? If there is none, next meeting, January 22, 10 a.m. Will someone move for the adjournment of this meeting? Thank you, Senator Golding, seconded by Senator Sinclair. Thank you all. May you have a productive rest of the day.